Hi, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about courts versus administrative tribunals. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Letestu, who owns a company called Ritlin Investments, had a residential tenancy dispute. And in all the provinces across Canada, disputes about tenancy agreements are supposed to be done by way of a residential tenancy tribunal. In British Columbia, we use the residential tenancy branch. Unfortunately, Mr. Letestu didn't really care for the way that the residential tenancy branch did things, and didn't really care to participate in their scheme. He felt that his disputes were outside of what the residential tenancy branch would allow him to dispute. And so he brought his application in the first instance in the Superior Court of the province. By bringing his application in that forum, he risked having his action thrown out because he didn't engage the jurisdiction of the tribunal in the first place. This is something that I've tried myself in British Columbia, and the courts repeatedly say, no, you have to ask the tribunal for a remedy, even if the tribunal can't grant that remedy. It's ridiculous. How can you go to a tribunal and ask them to do something you know that they can't do, and then complain to the court that they couldn't do it? And so Mr. Letestu and Ritlin Developments decided to try and do an end run around the residential tenancy branch in that province and bring his action to the Superior Court, relying on the inherent jurisdiction of the court to settle disputes within the province. His claim was rejected, and he appealed. He was rejected at the appeal level, and he sought leave from the Supreme Court of Canada, which was dismissed. This case raises that very interesting issue. If you can't get a remedy from a tribunal, and you know they can't do it, why would you waste your time, your money, and resources of the tribunal trying to get that remedy? And then, if they turn you down because they can't do what you're asking them to do, how can you judicially review a decision where it's not unreasonable for the tribunal to refuse to do the thing you want them to do in the first place? This is a huge problem that faces all sorts of people dealing with the conflicts between administrative tribunals and the courts. The Supreme Court of Canada had the opportunity here to say, yes, you can resort to the court where the tribunal can't or won't do anything for you. And unfortunately, they left this in a situation for people who are, like Mr. Letestu, facing a tribunal that can't give them the relief that they need because it's outside the tribunal's bounds of authority. This bothers people and affects people all across the country. The Supreme Court of Canada had the opportunity to make things right and to allow people the chance to bring their claim in the appropriate forum while still retaining the jurisdiction of tribunals over the subject matter granted to them by statute, but still resort to the courts where there's something outside that realm. Unfortunately, this is an issue that's still not going to be resolved, and hopefully one day the Supreme Court of Canada will recognize the tension that exists in these types of cases and take it upon themselves to finally resolve it. Until then, we just have to keep waiting for other cases, hopefully not cases that should have gone to the Supreme Court of Canada, but like this one, didn't. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation, and thanks for tuning in to Cases That Should Have Gone to the Supreme Court of Canada but didn't. Like, subscribe, share with your friends, and thank Brazen Bull for bringing you this production.